Okay. Jefferson County Court of Law number 2 is now in session. The court is in session. In cause number 23CCCR 2198, case is filed the state of Texas versus Elder Maldonado. Mr. Maldonado, is that your full name?
No.
Okay, what's your full name?
Elder J. Maldonado Valdez.
Okay, Elder J. Maldonado Valdez. Okay, Mr. Maldonado, how are you doing?
Pretty good, how are you?
I'm doing fine. Thanks for asking. Mr. Maldonado Valdez, you're represented in your case by your attorney Noel O'Bailey. And Mr. Bailey, again, how are you doing?
Fine, thank you, Judge. How are you?
I'm doing fine. Thanks for asking. State is represented in this case by attorney Quentin Price. Attorney Price, how are you doing?
Doing well, Your Honor.
That's good. Now, Mr. Bailey, I have before me a document that has been filed by you. This document is titled Defendant's Motion to Reinstate Bond. And Mr. Maldonado, you filed the motion. You can go forward with presenting your motion.
Yes, Judge. What happened, Your Honor, Mr. Maldonado has a warrant for failure to appear at his arraignment setting on March 28th. That was his first setting. I had an arrangement with the court staff that if my office filed a notice of appearance on the case prior to that date, then there would be an automatic reset. And I told Mr. Maldonado that I was going to file the notice of appearance and his case would be reset, so he would not have court on March 28th. My office, my fault completely, we did not file the notice of appearance as arranged, and so Mr. Maldonado was issued that failure to appear on March 28th. So he is totally blameless, Your Honor. A mistake on my part. So I'm just respectfully asking the court to reinstate the bond. If there is some penalty for my office, I'll be happy to accept it, Judge. But the reason he didn't show up on March 28th was because we told him that setting was going to be reset because we mistakenly believed that we had actually filed the notice of appearance before March 28th.
Okay. Mr. Price?
Your Honor, the state has no objection to that. And I spoke with Mr. Bailey, and Mr. Bailey indicated that it was, I think he actually did try to file timely, but it was the filing system didn't get it done until a day or so later, made his appearance. So we have no objection with this. Mr. Maldonado has now appeared in court. So we have no objection to reinstating the bond, recalling the capias, and recalling the judgment nisi in this matter.
Okay, because I was just looking at the notice of appearance. The letter of rep was filed on April 5th of 2024.
Yeah.
He missed court on March 28th of 2024, which is like, I guess, a week before.
Right.
Something like that.
Okay. And what I understand was that Mr. Bailey had attempted to file, didn't realize that he hadn't filed until, a few days later, and then filed his notice of appearance.
Okay, so you're saying there was no filing ever made? He had never filed, because when I was reading the motion to reinstate, he said there was an error when e-filing the notice of appearance. And so I was thinking, if there was an error e-filing, it seems to me that it was filed, but it was an error
to be filed. Right.
So it was never filed. I mean, that's what I'm getting from him.
That's right.
You have made a notice of appearance.
Yeah, he's made a notice of appearance since the motion to since the judgment nisi has been filed, because the judgment nisi was on the March 28th of 2024, on the same day of his failure to appear.
Mr. Bailey, what was the date that you actually filed your notice of appearance or attempted to file with e-file?
Sir, it was prior to the 28th, and I was, I realized that it had not been filed when I saw that a failure to appear had occurred on the 28th, and that's when I went and looked, and it appeared we never filed the notice of appearance prior to the 28th.
Right. So you never filed it.
Well, but Your Honor, it's my understanding, at least on the civil side, and I can't really comment on the criminal side, but on the civil side, if you attempt to file something on a given date and it's rejected or for whatever reason, once it is ultimately filed, it dates back to the original attempt to file.
Yeah.
Now,
Now,
proper
if he had filed and it was rejected, he would have received a return informing him that it was rejected. But I don't think he's saying that.
Are you not saying that, Mr. Bailey, that it was rejected?
No, sir. No, we thought we had filed it and then realized that we had not filed it when we saw the situation with the failure to appear.
Okay. So he's saying he never filed. He thought they filed it, but they didn't file it.
It was just an office mistake where where you thought that somebody else had filed it and it had not been filed?
Yes, sir. I believe my paralegal, Felix Ramirez, I think he's the one that spoke with you. We thought we had filed it, and we never got a rejection notice. So apparently it was never filed.
Never.
Before the 20, before the appearance date.
So once he found that out, he files it on April the 5th.
Right.
I guess which is after the judgment Nisi,
right,
which was March the 28th.
Right. Given the short time period in between the time of the default on March 28th and the filing of the notice of appearance, the state has no objection to, like I said, just recalling the habeas and recalling the bond as well. The bond forfeiture as well.
Okay, now let me ask you this here now, when we're talking about exoneration, I guess under Article 22.13,
right,
3, if the sickness of the principal is one reason, or if there's some kind of uncontrollable circumstances that prevented the appearance at court, that prevented the appearance of the principal or the defendant at court, and in such cases, the failure to appear arose from no fault on the principal or the defendant's part.
Right.
Okay.
And I think when the lawyer tells the client that they don't have to show up because we're going to file a notice of appearance, which will automatically reset your initial appearance date, that's not Mr. Maldonado's fault for that occurring.
Okay. And when we say that it's uncontrollable circumstances, I guess at this point, the circumstances is in the control of the attorney.
Correct.
Who informed Mr. Maldonado that they were going to file an appearance. And based on the filing of that appearance, he did not have to appear because that's what he was informed. Well, that's the policy of the court anyway. I mean, if you file an appearance, you don't have to, because the case is automatically reset. Right.
So the attorney can be present when you do the initial appearance.
Right. And then so, once he makes an initial appearance, he makes an announcement, either that he wants to reset it for an announcement so that he can get time to get the discovery, do an investigation, have consultation with his client, as well as negotiate with the district attorney's office.
Right.
Okay. Okay. So the state is not opposed to the exoneration. Your client is present in court because that was one of the requirements of Article 22.13 that the a principal had to be present in court for this matter. And so therefore, based on that, the court will reinstate the bond that was forfeited on March 28th of 2024. Now, let me ask you, is this case still pending or not?
The criminal case or
Yeah.
bond forfeiture? I think both are still pending. Are they not?
They're
Yeah,
still pending, Judge.
Yeah, okay. I want to make sure.
Yeah.
Okay,
All right, Your Honor.
so you're gonna submit an order?
We will, Your Honor.
Okay.
Yes.
The state will submit an order to the court. Actually, it's basically by agreement, I guess.
Right.
It's an
Yeah.
agreed order.
I don't think we do an order in criminal.
We don't do the order in the criminal.
So,
Well, but I mean, whatever the court
Is
does
this
on the
hold on.
recall.
Did he have an order attached
Yeah,
to his motion?
yeah.
Okay, he has an order attached to his motion.
Oh, okay.
Okay,
Order on the single motion reinstatement.
yeah, I have an order.
Yeah.
Okay,
No
so,
objection to that, Your Honor.
okay, so the court is going to grant it.
Yeah. And that's filed in the criminal matter. We will then submit in the bond forfeiture matter a motion to dismiss the bond forfeiture.
Okay,
We will submit that order.
okay.
And I will
Now,
copy you on that, Mr. Bailey.
Ms. Bennett,
Thank you, sir.
okay, just hold on a minute. We need to get the court coordinator so we'll give him a court date.
yes, sir.
Because as right now, he doesn't have a court date.
Mr. Bailey, is it all right if I speak with your client for just a moment to make sure that we still have a current phone number for him on the bond, the cash bond that he filed?
Yes, sir, and I'll be contacting you shortly regarding trying to resolve the case. But you may
All
speak
right.
with him, yes.
Okay, we're gonna reset this case. Got it. The warrant is been recalled. It's gonna be recalled. So we
Okay.
need to give him a court date.
Okay.
And Mr. Bailey,
Yes, sir.
we're gonna reset your case for an announcement.
Yes, Your Honor.
Give us some dates.
You want it on a Monday or Wednesday?
A Monday or Wednesday
Okay.
or Friday, which one is best for you?
Wednesday, Judge, what date?
Okay,
Okay, hold on one second. Let me give you. We have July 17th, the 24th, or the 31st.
okay, July 17th, July 24th, or July 31st?
31st. I'll do the 17th, Judge.
Okay,
Okay.
okay, now, Mr. Maldonado, you're gonna get your reset here in court. Once you get your reset, you're free to go. And you have a blessed day. Stay in contact with your attorney. And Mr. Bailey, your reset will be sent to you. You're free to go as well, and you have a blessed day.
I apologize for what happened, Judge, and thank you very much.
Okay, you're welcome. And Mr. Price, you're free to go as well, and you have a blessed day.
You too.
And this will
Mr.
conclude.
Price.
Okay.
You're welcome.
Okay, and this will conclude the calling of this hearing on today's date of May 31st, 2024, in County Court at Law Number 2, Jefferson County, Texas. Judge Terrence L. Holmes presiding. Everyone, please have a blessed day.
You too, Judge. Thank you.